Welcome back, ladies and gentlemen. For those who have just tuned in, welcome to the SIAC Virtual Congress 2021, and thank you for joining us. I am now delighted to introduce the panel for our plenary session, How International Arbitration and International Commercial Courts Play Unique, Important, and Complementary Roles in International Dispute Resolution. We are greatly honored to have with us today the Honourable Justice Judith Prakash, Justice of the Court of Appeal, Supreme Court of Singapore, the Honourable Justice Beverley McLachlin, PC, International Judge of the Singapore International Commercial Court, the Honourable Mr. Geoffrey Tao Lee Ma, GBM, former Chief Justice of the Hong Kong Court of Final Appeal, and Dr. Michael Hwang, SC, Senior Counsel and Chartered Arbitrator at Michael Hwang Chambers. The co-moderators for this session are Professor Lawrence Bu, member of the SIAC Court of Arbitration, an independent arbitrator at the Arbitration Chambers, and Dr. Michael Pryles, AOPBM, independent arbitrator. A warm welcome to our distinguished panelists and moderators. Professor Bu, Dr. Pryles, please.
Thank you very much indeed. Michael Pryles speaking, and I'm delighted to be joining you all in this plenary session. As we all know, arbitration has come to the forefront of international dispute resolution in the last 3 or 4 decades. But arbitration doesn't function in isolation to other institutions. And in particular, the interaction between arbitration and the courts is vital to both institutions in a sense. Now, the title of this session focuses on the complementation between the international commercial courts and international arbitration. And that is one of the most important aspects which we'll be exploring during the course of this session. But I think we would be perhaps a little naive if we didn't also admit that there is perhaps an element of competition, or at least a perceived element of competition between the two as well. So we're going to look at the balancing. How do we complement each other? Is there competition and other related matters? Of course, while arbitration works together with the courts, we have also seen the establishment of specialised international commercial courts. And we have one member of the Singapore International Commercial Court on the panel today. The other panel members who have just been introduced have outstanding experience in international dispute resolution. So we're looking forward to a vibrant and interesting session starting now. In addition, we would like to invite everyone who is viewing to put forward questions to the panel online via the chat icon on your screens. So the way we proceed, we propose to proceed this morning is that Professor Bu and I will ask certain questions of the panel. We will also monitor the questions which the people viewing may have, and we'll get through as many questions as we can. Some are broad, no doubt, looking at the interplay of the two institutions, and others will be specific and targeted on particular issues. So with that brief introduction, welcome, and I hope you enjoy the session. Professor Bu, would you like to ask the first question, please?
Thank you, Dr. Pryles. There are two Michaels here, so I'll be addressing them as Dr. Pryles and Dr. Hwang. So, and there are quite a few judges here, so allow me sometimes if I miss addressing you properly, just forgive me. I thank you, Michael, for the introduction and indeed for highlighting the banner statement that we have. So first, my first question, therefore, is to the panelists is, do you agree with the banner statement of this session, and that is international commercial arbitration and international courts play a complementary role? And as suggested by Michael in his opening, that there could well be some perceived sense that there might be either some level of competition between the two. And let me invite the Justice Geoffrey Ma to kick off by sharing your views. Judge Ma, please.
Thank you, Lawrence, and good morning to everybody. I'm glad to be a part of this marvelous conference. Now, the question which you raise, it's capable of a short or long answer. We don't want a long answer. The short answer in terms of complementary roles, of course, is yes, but it's actually more important to put this part of the discussion which we're about to have in context. Now, the first part of the context is that most of the people participating in this conference will come from jurisdictions in which there is a statutory leaning towards the courts having a complementary role. This is sometimes referred to as the courts supporting arbitrations. We all know what those are, supporting roles in terms of enforcement, in terms of the granting of interlocutory relief and so on. So the complementary role is certainly there. The competition part is an interesting part of the question. I don't see competition in the sense that the courts and arbitrations are somehow vying for a share of something or a share of the market. Certainly, as far as the courts are concerned, they're not vying for or hoping for a greater share of litigation or the resolution of disputes. In fact, very often, quite the opposite. Where I see the competition aspect, and to put this in overall context, is that both courts, take an overall view, both courts and arbitrations are part, if you like, of what we lawyers like to refer to as the administration of justice, meaning the ability to resolve disputes properly, justly, and basically well. Now, both arbitrations and the courts have really got to up their game and continue to up their game in order to provide actually the service which litigants expect in the resolution of disputes. This is where the competition part comes in. And this is where, at one stage, unless they were forced to, courts and arbitrations didn't really work that much together. This has actually very much changed. And we see a closer interrelationship now between the way arbitrations and the way courts work, so that there's much more of a, if you like, a symbiotic relationship between the two, whereby both institutions recognize of course, their strengths, but also their weaknesses, and in turn, try to borrow from each other in the resolution, of course, in this context, of commercial disputes. So that, I think, is the way first to answer this rather general question. I don't know whether other panelists have views on it, but this is the way I see it.
Thank you, Justice Ma. I think that is a great start. I think a difference might be the question that we are focusing on is actually international commercial courts, while domestic state courts do have a role in the enforcement and the setting aside and the other roles that are normally associated with supportive of arbitration. Here, the specific focus we are talking about is in international commercial courts. Maybe Justice Prakash, who is also in both the Singapore courts as well as the Singapore wing of the courts, sitting in Court of Appeal, as well as the International Court Division. Maybe she can share with us her views on the SICC and how it operates, and see how that complements international commercial arbitration. Justice Prakash?
You're on mute.
Okay, good morning. I hope you can hear me now. Thank you, Lawrence. Yes, well, the Singapore International Commercial Court actually was set up because it was perceived that there was a need for an institution, a court institution, which was specializing in international commercial dispute resolution. I hope that's not considered a Freudian slip. And it was thought that there were certain areas in which perhaps we could complement the services to international dispute resolution which are offered by arbitration. As you point out, Lawrence, domestic courts usually have played a role in enforcement and also setting aside of arbitration awards, pursuant mainly to the implementation of the model law. But in dealing with international disputes, domestic courts are limited by their jurisdictional requirements, and also to an extent by the fact that they deal basically with domestic law. So while certain domestic courts have developed reputations as international commercial dispute resolution centers, it was thought that a specialized court could be set up, which could, as Justice Ma has pointed out, borrow from certain best practices in arbitration and offer an alternative. So, for example, when the Singapore International Commercial Court was set up, it was decided that it should have an international panel, which would be drawn both from the common law and the civil law jurisdictions. Singapore, as you know, is a common law jurisdiction, but many countries around us are civil law jurisdictions. Then it was decided that we should be able to adduce foreign law by way of submissions of counsel and decide it as a question of law rather than deciding it as a question of fact, which was what is done in the domestic courts. Apart from that, we have the situation that we are much more flexible in terms of evidential rules, because we have got simpler rules and modeled on the arbitration model rather than our Evidence Act, which apply to proceedings in the Singapore SICC. We also allow parties to use their own counsel, in the sense that foreign counsel who are not registered practitioners for domestic courts in Singapore can register at the SICC, and parties will be able to appoint them to conduct their matters. So in many ways, I think we have reproduced the element of choice in the SICC, which is available to parties in arbitration. We also have the prospect of appeals. I think that is something that, well, people who go to arbitration at the time they sign up for arbitration may say they do this because they want a final resolution. And they know that there's no appeal in arbitration. But subsequently, when a party loses, it is sometimes not happy to accept that result. And of course, then it tries to set aside the award. But at that time, it might reconsider its idea about an appeal. So for those people who anticipate that they might want to have a second bite of the cherry, they can use the SICC. I mean, the SICC is voluntary in the sense that we have got an opt-in procedure from international parties. We also do transfer certain cases with the international aspects from the Singapore court to the SICC. But the idea is basically to provide an alternative forum for people who see that our features will assist them in resolving their disputes. And of course, I should say that there are some areas where in arbitration cannot apply because the kind of dispute involved is not arbitrable. For example, in relation to insolvency matters. And in that case, the SICC is available. So I do think we are complementary. There may be considered to be a bit of competition, but the field of international commercial relations globally is so vast, actually. That is why international arbitration has grown the way that it has over the past 3 or 4 decades, that I think it's just a question of, providing a buffet rather than competing and leaving it up to parties to decide what they want to do. And the great advantage of an international commercial court like the DIFC or the SICC is that not being constrained by domestic policy, the procedures can be tailored to suit international parties. I mean, I think that's sufficient for me for the time being.
Thank you, Justice Judith, for enlightening us and showing us the examples of how it complements. In fact, there is a comment from one of the participants here to say that the court system, in terms of cost, is lower than arbitration, and therefore that itself is an element of competition. Do you agree with that?
Well, the court system here in Singapore domestically is lower than that of arbitration. But as far as the costs awarded in the SICC are concerned, there's a much more flexible system, and we are not tied to a Singapore policy regarding access to justice for individuals. International commercial disputes are generally between very large corporate entities who don't consider cost to be a factor in their litigation. And in that circumstance, I think that the cost awards have been and are likely to be rather higher than they would be in the domestic court.
Yes. Connected with that, Justice Prakash, can I just ask whether or not the SICC itself is what, self-funding, or is it dependent on taxpayers' contribution?
Well, the SICC, of course, charges fees, as the domestic court does. I'm afraid I don't know completely about the budget, but it is supported by the government, as the domestic court is. And for one thing, apart from our panel of international judges, like Justice McLachlin,
yes,
with 12 of them in all, we have a whole panel of local judges who also serve on the SICC. So, well, we work in Singapore. We are funded in Singapore.
Good. Thank you so much. And I think we have just mentioned Justice C.J. McLachlin. May I ask her to contribute also in Canada? I don't think you have an international court, maybe as yet. Any views on that or contribution you want to make, C.J.?
No, we don't. Thank you very much. It's lovely to be here with you and discussing this fascinating subject. We do not have international commercial courts in Canada, but there is an intersection between the courts of the country and arbitrations. And I must say, I see these two dispute resolution mechanisms as very complementary. I really don't see it as a matter of competition. Arbitration presents certain advantages that commercial people involved in commercial disputes like to take advantage of. They can choose who they want to have to some extent. They can have their matter heard privately, and they can, to some extent, tailor the rules and what's going to happen. So all of that makes arbitration an attractive option, and that's why we see so many contracts that say if we have a dispute, we're going to go to arbitration. But we have to remember that arbitration is set within the context of the rule of law more broadly. And every agreement that says we'll go to arbitration, well, most of them will say what the law that the arbitrators are going to apply is. Is it the law of this country or that country? So even in a substantive way, arbitration is dependent on the laws that have been formulated by judges in courts to some extent. In addition, as has been noted, courts are essential for enforcement, for review, and we have had a little bit more robust review by courts of arbitral decisions in Canada, perhaps, and in some jurisdictions. But in substance, right now, I'm involved in an arbitration, and it's a very high profile arbitration with a country involved as one of the parties. And a constitutional issue has been taken before the courts, which now there has been a judicial decision on it. And now I, as an arbitrator, am working with my co-arbitrators to see how that decision is going to impact our arbitration. So, because we are applying the law of that country, and what its court decided in a constitutional matter may, I'm not saying it will, but the allegation is it may impact it might impact the issue before us. So this has brought home to me how we are all involved in, as Chief Justice Ma said, the administration of justice. And we are doing it in different ways. Perhaps to some extent, parties are free to arbitrate and choose arbitrators, but without that cradle of the legal framework that is staffed by courts and kept going by courts and supported by courts, arbitration wouldn't amount to much. We wouldn't have perhaps enforcement as we should have. We wouldn't have review to the extent we may, and we might not be able to, as arbitrators, deal with certain issues that really are legal issues for the court, such as fundamental constitutional issues. So the more I do this, I sit as an arbitrator. I also sit as an external judge on the Singapore Commercial Court, and I love that. I think they both offer great advantages, and I really have to say I agree with Judith that the Singapore International Commercial Court seems to do an excellent job of just getting to in a way that's flexible, has borrowed traditions from arbitration and so on. But there's a place for arbitration too, and I think Geoffrey Ma's right when he says we have to work together to make sure that system is as good as we can make it be.
Most definitely, most definitely. Thank you for your input, Chief Justice Beverley. In fact, what you have brought up is a problem that I can see also in investment state disputes, where currently there is a great tension between the EU courts and the investor state arbitral tribunals in relation to whether or not intrastate investment dispute should be in the EU courts or should be in investor state under exit convention. So there is this very brewing tension between the two that has to be resolved somehow. Maybe not competition, but it's a real problem with that.
Yes.
Let me just move on to actually Dr. Michael Hwang, who is actually served as the Chief Justice of DIFC for a long time, and I'm sure he can bring to us a different perspective, both as an arbitrator and as a judge of an international commercial court. Dr. Hwang, please.
Thank you, Lawrence. Good morning, all. In 2014, I delivered a public lecture in Sydney, and the title of my talk, which is later published in Arbitration International, was, are commercial courts and international arbitration competitors or partners? My short answer is both. We are competitors because both international commercial courts and international arbitration are appealing to the same target audience. The target audience is cross-border transactions where neither party wants to have any dispute resolved by the national court of the other party. And they're basically looking for four things which international arbitration traditionally offers. First, a neutral tribunal. Second, confidentiality. Third, if parties are from different legal traditions, then the possibility of having a tribunal with arbitrators representing both traditions. And finally, flexibility in procedure. And that's where the SICC has come in to aim at that particular market and to offer these four attributes of international arbitration, which are not traditionally offered in traditional courts. We can explore those aspects in the next topic. But SICC from the beginning has said that its target audience is actually cross-border transactions where parties want neutrality, but for whatever reason do not want to go to international arbitration. I don't have the time to go into what are the doubts about international arbitration, but that particular market exists for SICC to tap, and SICC has addressed the four attributes of international arbitration, which I have just mentioned. I think that's all for now.
Thank you, Michael. Thank you. Just before we round off on this, may I just ask Justice Ma again whether Hong Kong, where you were Chief Justice for a while, have any plans for an international court, or is it like Canada? They don't have no plans.
Mute.
I'm sorry. I think
I'm sorry. I better
No.
unmute myself. Sorry.
Yes, yes.
I'll start again. We've been talking about this in Hong Kong for a little while, with particular impetus when Singapore started the SICC, which is a marvelous institution. We felt in Hong Kong there was no need to have a special international commercial court. Our existing commercial list, which is a very busy list, can handle the type of litigation, the international commercial litigation, which we experience and still experience in Hong Kong. So there was no need for that. I mean, our, if you like, panel of overseas judges sit as non-permanent judges of the Court of Final Appeal, but then that's not a specialized commercial court. That's just a final court of appeal, which hears cases from all sorts of areas. No, the short answer is no, Lawrence, with no plans, I think, for it. Just for Hong Kong's particular circumstances, there is no need.
Thank you. I understand that. What about CJ Beverley? Anything you want to add to that? Are there plans in Canada to do so?
Not that I know of. Not that I know of.
I see.
No.
Okay.
Maybe might be something brewing I'm not aware of, but no.
Okay. Thank you. Thank you. On that, I will just ask maybe Dr. Pryles to bring us on to another topic.
Very good. Thank you. So from the broad topic, the interrelationship between the two methods of dispute resolution, to a specific narrow issue, does complementation extend, and should it extend, to use of the same personnel? In particular, is it appropriate for a member of an international commercial court to act as an arbitrator in the jurisdiction of the court. Let me give you two scenarios, but there are many more. One is that I've been appointed an arbitrator in a case, and the arbitrators, the co-arbitrators, have to search for a presiding arbitrator. Now, is it inappropriate for me to approach a member of an international commercial court to see if he or she is available when I have knowledge that that court is presently considering an appeal from one of my previous awards in relation to the existence of jurisdiction? Does that court, is there a conflict, or is it improper? A second point, would a member of an international court be embarrassed to take a position as an arbitrator within the jurisdiction of the court, knowing full well that there could conceivably be an application to that court by a party to set aside a decision in relation to jurisdiction? Now, obviously, the judge arbitrator wouldn't sit on his or her own case and decide whether the exercise of jurisdiction was correct or not, but would it be embarrassing for the other members of the court to have to consider whether a fellow judge made a mistake as an arbitrator? And I'm going to ask the Honourable Geoffrey to speak to this, because we have discussed this a bit. But before I ask him for his views, let me just say that I am aware of a member of the court of which he presided as Chief Justice over, who is a friend of mine, who was a member of his Court of Final Appeal, and he said to me he had a principle that he would never take a case as arbitrator in Hong Kong. So he took the view that there were, if not conflicts, possible embarrassments if he did so. Others, of course, are of a completely different opinion. So, Justice Ma, could you please let us have your views?
Thank you, Michael. Now, I think the first point is a back to basics point. We've got to know what we're talking about here. We're talking here about conflicts of interest, actual or perceived. Forget about actual, because we all know what happens when there's an actual conflict of interest. It is a perceived conflict of interest, which is important here. There are many established rules and much established law in relation to what constitutes a perceived conflict of interest. I won't bore you with actually stating what the principles are. I think we all know what they are. Now, translated into the topic that you've introduced, Michael, it is this. I see no reason in principle why a judge in a jurisdiction cannot sit as an arbitrator. I mean, not a sitting judge, but with various exceptions, why that person cannot sit as an arbitrator in that jurisdiction too. The anecdote or the person you talk about, I think I know who it is. The sensitivity in relation to that person sitting as an arbitrator in Hong Kong while it was a he, was sitting as a judge of the Court of Final Appeal was this: during the time that he was sitting as a non-permanent judge of the court, which is for a month's duration, it would not appear very good, very well, if that person was to sit in the evenings or in the afternoons when he had some spare time to sit as an arbitrator. That wouldn't go down very well at all. That's not a conflict of interest issue. That's just, well, I suppose it is. It's a perception issue. But there have been many non-permanent judges who sit in Hong Kong, not during the time they're sitting as judges, but at other times sitting as arbitrators, and there's nothing wrong with that. I see no difficulty in principle. I know that Michael Hwang may have a different view because we discussed this a few days ago. I myself do not see that. Indeed, I see a strength in a judge of a court, say the Singapore International Court, also having sat as an arbitrator in Singapore, because actually this goes back to the complementary roles which arbitrators in courts have, because when it comes to, I'll give one example, when it comes to the enforcement of an award, sometimes, as we all know, all sorts of points are taken. Some are really quite extravagant. Some are extravagant points which are dressed up as very serious and difficult points to adjudicate. Now, in order to adjudicate on these points, one needs to have a feel for the arbitration award or the arbitration scene from which the award comes. And this is where a knowledge of a person, both as arbitrator and a judge, comes in useful, because without that, one is left a bit at sea, actually. We have cases in Hong Kong in the past, I'm glad to say, whereby judges who are completely unacquainted with arbitrations, or indeed even commercial cases, are asked to enforce awards or not enforce awards. So anyway, the short answer to your this question, Michael, is that, of course, it depends on the law, as specific cases demand specific answers. But generally, I see no conflict. Indeed, I see a strength.
Thank you. In relation to one of the points you just made, that it's preferable for a judge who will sit in relation to arbitration matters, either to enforce an award or set it aside, has an intimate knowledge of arbitration and experience of it. I think I completely agree with you. But that could be acquired by allowing a judge of an international commercial court to sit as arbitrator in other jurisdictions. But any perceived embarrassment which might arise if the person acted as arbitrator in a case seated within the court's jurisdiction could still be avoided, perhaps by an exclusionary rule, but it may not be necessary. Anyway, you mentioned—
Can I come in on this? I'm sorry to interrupt. I apologize.
Yes, yes. I was just going to ask. Sorry, go ahead. Go ahead, Beverley.
Go ahead. No. Go ahead.
No. Please go ahead, and then we'll go to.
Well, I was just on this point of embarrassment, because we had a tradition in Canada in the early years when there weren't very many people and it was colonial administration. There wasn't separate courts of appeal. And so when someone appealed a judgment from a trial judge, it was always men, brother judges had to get together and they sat en banc as the full court and they would hear the appeals. And so we in my country are very used to the idea that judges can be part of the same collegial court, and yet one can sit, some can sit in judgment on the other. And it never has really been discussed in terms of embarrassment or anything else. If you get overruled, well, it was a question of law and you're still good friends and your colleagues. And so maybe I'm missing something on this embarrassment point. So it was really just a question more than anything else.
I would like to chip in here too.
Yes.
Because the situation that Beverley describes was the situation in Singapore until the 1990s, when we established a permanent Court of Appeal. And before that, the Court of Appeal consisted of the Chief Justice and a couple of senior judges on an ad hoc basis. People who generally sat as High Court judges were sometimes put into the Court of Appeal, but it was an ad hoc Court of Appeal. And we all lived with that. And I think for judges, perhaps the situation is not as sensitive as it might be for arbitrators or people who've not been judges, because we've been living in this ecosystem where you know, when you start out anyway, and you're in the High Court, that your judgments are going to be reviewed, and quite are not uncommonly, let's not hope frequently, but not uncommonly, they are going to be disagreed with, because as lawyers, we have different views on the law. And so you grow up in that sort of a situation judicially. And as Beverley says, you continue to be good friends and colleagues. It's just that you respect each other's different roles.
Thank you. Michael Hwang. You're on mute, I think. There we are.
Thank you, Michael. When we started the DIFC courts, the first Chief Justice, Sir Anthony Evans, and I, we agreed on a policy that none of the judges in the DIFC courts would accept arbitral appointments where the seat of the arbitration was the DIFC. The DIFC is an independent arbitral jurisdiction center. So we agreed that we could take appointments where the curial court would be the Dubai National Courts. So if the seat was Dubai, which in our interpretation excluded the DIFC, we could take on arbitral appointments, which I did. But we agreed between ourselves that we didn't want that situation arising for a couple of reasons, one of which was the embarrassment factor when we are still trying to build the High Court itself. And the same situation as in Canada and in Singapore applied. All of our High Court judges were also Court of Appeal judges. But there was also the theoretical possibility that if there was an arbitration seated in the DIFC with one of our judges, and that award came up to the DIFC courts on a challenge, then one of the parties might object to the entire court hearing that, setting aside, on the grounds of possible conflict, and we would have to have it argued out. At that time, and until very recently, that really wasn't a big issue. But the reality is that all of our overseas judges in the DIFC are also part-time arbitrators, because, and this is an interesting observation, I think in all of the English-speaking commercial courts around the world, they're all, 90% of them are manned in the sense of populated rather, by retired judges from the English-speaking countries, primarily England and Wales. So you have all these retired English judges who want to have a second career as arbitrators, and they will take on arbitral appointments as well as appointments in the international commercial courts. So you've got DIFC, you've got Astana International Financial Center Courts, you've got Qatar Financial Center, you've got Abu Dhabi Global Markets. All of these are populated by, mostly by retired English judges, but also Welsh judges, and also some from the British Commonwealth. So it is a reality, and I think things are not going to change in the immediate future in any of the international courts.
Thank you very much, Michael. Okay, well, I think that's a very good coverage of the topic. And
Michael, there's actually a question or a comment from the participants who say that
yes,
the perception of a conflict of interest is very real and it's a factual one, in particular in international arbitration. So I think the comments from CJ, Beverley, and Justice Prakash on the court system, where judges are used to being judged by their own peers, decisions being scrutinized by their own peers, is something probably is special to the judiciary. There are people who are different. They can accept that. But in the international area, more in the marketplace as such, this perception may be more sensitive, like what Justice Prakash says. And on that note also, I was thinking that in the Singapore context, for example, you have the domestic state courts, the High Court, and you also have the SICC, a division also of the courts. Perhaps maybe one solution to it is not to mix the two, and that they have the SICC courts or the international division deal purely with commercial disputes and not to deal with enforcement of awards. That will divide the two. There will be no perception of possible conflict or they ruling on fellow arbitrators or whom they have set before before the SICC court. That may help actually, rather than to mix the two. I think currently there is a mix of that, and that may not be good for perception in terms of the role of the SICC. So that could well be something to consider. Justice Prakash, any comment on that? Since I'm talking of the SICC as an example.
Well, I don't know. I mean, you have that particular view, which actually conflicts with the other view, which Justice Ma has expressed, which is that it really helps in deciding on enforcement or setting aside applications if you have a feel for international commercial disputes and a feel for how arbitration is conducted. So our judges of the Supreme Court who are on the SICC are permanent judges of our court, of course, and do not sit as arbitrators.
Right.
All right. So I think one of the reasons for the SICC being set up was to bring in different experience, and commercial experience, which would help in the adjudication of such disputes. There are, of course, some of us who have had a commercial background and who have been arbitrators. I'm talking about judges of the High Court, but not all of us have been. So I still think it is good to have the additional experience of the international judges in what can be very complex disputes, and as Justice Ma says, can be, when a case comes to court for setting aside, it is marvelous to see the really intricate arguments that can be built around what perhaps one might consider is a simple point, but whether there's been a breach of natural justice or not. And I think in such situations, it may be helpful for the adjudicator, the judge, to have the experience of arbitration to decide whether this is a fanciful argument or something that is really real.
Justice Prakash, may I come in on that? Do you think that one of the reasons that arbitrators are held to a very, very high standard in terms of conflicts, real or perceived, increasingly so, there are so many challenges, most of which are dismissed, but nonetheless, the scrutiny is extraordinary at times, and that also compounded with the overriding emphasis on due process in arbitral proceedings. Has that followed from the fact that generally there are no appeals from an award, and therefore a dissatisfied party in an arbitration is forced to either challenge an arbitrator or allege a procedural impropriety in order to try and overturn the award. Is that the motivation?
I think that is the motivation. I mean, you've expressed it very clearly, because a party who is dissatisfied with the award that has been rendered is not able to appeal even on a question of fact. There are some moves to have a limited right of appeal in the SIC, against arbitration awards in Singapore. But I think that the consensus has been that in order to have a right of appeal, you'll have to consent to a right of appeal before the dispute arises, which means basically in the contract at the very beginning. But at the moment, there is no appeal for international arbitrations on even a question of law, much less a question of fact. And when an arbitration has gone very wrong in the view of one of the parties, I suppose they have no recourse except to challenge it on the basis that somehow due process has not been followed. And these arguments, as I said earlier, become very elaborate.
Thank you. Beverley, has Canada developed a notion of egregious error in an award to justify overturning it on its merits?
It depends. Thank you. It depends on which province you're in, because every province has its Arbitration Act, and that contains a provision that sets out when it can be set aside. But there is, I think in Quebec, the concept of egregious error, and in other jurisdictions, error of law. And then you get into elaborate arguments about what's an error of law and is it extricable and is it mixed fact and law. But so there is a little bit of wiggle room to argue that an arbitral award should be set aside on the merits in Canada, generally speaking. I have to say, though, that courts seem to take on the whole a very strict view and don't lightly interfere with arbitration awards. They don't, not nearly as readily as they might take on an appeal from, a lower court decision. There's a sense that if you go for arbitration, you intend that to be final, and it's only a clear error of law or some egregious error that has sent the thing off the rails. But in those rare cases, and I have to say they're pretty rare, I think, you may get, depending on where you live in Canada, where the dispute takes place in the arbitration, you may get, you may have a way to set it aside. It's a bit of a dilemma. If you go too broadly and say, well, then that the Court of Appeal can get into the merits, then you really destroy one of the important things about arbitration for many parties, which is that it's going to be settled and they're going to move on and they're not going to be tied up in litigation for what can be a very long time in many jurisdictions. And so I think courts take a pretty strict view of it, even in Canada.
Thank you very much. Lawrence, I think your turn for another question.
Let me just carry on from there, just pick it up from what has been shared so far, talking about judges maybe hearing whether it's an enforcement of an award or to set aside an award under Article 34 of the model law that comes before you. I think most of you who are sitting as judges would have opportunity, a chance to hear such cases. And I want to ask a very personal question, whether or not you have, when hearing such cases, ever applied your mind to the merits of the case, in a sense, whether consciously or unconsciously, be influenced by the way the decision has gone. Does that play a part in how you make the decision on the application? maybe Justice Prakash. I have read many of your decisions. So I thought I want to see whether I can go behind that.
I have resisted attempts to make me look at the merits. Michael Hwang, when he was counsel before me in a couple of cases, has tried very hard to make me look at the merits, and so far I have resisted.
Well done.
I don't think it is fair for me to look at the merits when you come up before me on a setting aside, because I don't have the material on a setting aside application that I would have if I was doing an appeal in the Court of Appeal. In the Court of Appeal, we get the whole transcript, and then we get all the documents that were produced below. And so we have a lot to dig into in our assessment of whether the decision was correct on law, and as well as on facts. But this doesn't happen in a setting aside application. And so I really am not qualified. There may be some times when I think the arbitrator has gone a bit far in his statements on the law, and I don't quite agree. I would have done something slightly differently. But I'm always conscious of the fact that I don't have a full picture. And so it is not for me to judge.
Yes, thank you. Can
I ask a slightly follow-up question to the judges? And that is to outline what may or may not be a significant difference between arbitration and an international commercial court. And please excuse my ignorance, but can a court decide a case not by applying the law of any jurisdiction, as an arbitrator can in certain circumstances?
A court, sorry?
Well, an arbitrator is, as we know, bound to apply the law chosen by the parties. But if the parties empower the tribunal to decide as amiable compositeur or ex aequo et bono, then the judge is to a considerable extent freed from deciding according to law. Alternatively, in an arbitration, there is no impediment if the contract provides that the governing law is not that of a state, but is that of generally accepted principles common to English and French law. There's wide latitude given to contractors to choose the law of a non-state. It's not widely exercised, but is an international commercial court able to apply principles like those I've outlined?
I don't think that the SICC has adopted such a practice, because court decisions do have precedential value, unlike arbitral decisions, and they can be criticized on misapplication of law. So in the SICC, we're always very clear as to which law we're applying and what comments we're making on it. And it's not just by the length of the judge's foot or the judge's idea of what would be a commercially reasonable law to have.
Yes, thank you.
Yes, comments from anyone on that? Previously, what we were talking about, how judges, whether perceived or otherwise, might have, or from maybe Dr. Hwang, actually. Yeah.
Yes. I gave a lecture at the Singapore Academy of Law conference some years back on this topic of egregious errors. And I did a lot of research on it and published an article later. Now, there are 4 jurisdictions, at least, which have admitted the theoretical possibility of a court reviewing a arbitral award on the grounds of egregious error, whether of law or fact. The 4 jurisdictions are Canada, Hong Kong, India, and Zimbabwe. The 2 which admit the possibility in theory are Canada and Hong Kong. In Canada, I tracked around 5 to 6 cases from different courts in Canada, including the Supreme Court, where this possibility is a throwaway line in some of the judgments, which say that, of course, if an error is patently unreasonable or makes a mockery of the law, then the courts can step in. But my research, which is actually up to date till 2020, is that this has never been applied to set aside or denial of enforcement for any arbitral award by an actual court in Canada. So it's only a theoretical possibility. For Hong Kong, it's somewhat surprising, and it's again a throwaway line. In one of the most famous cases to come out of Hong Kong, Hebei Import and Export against Polytech, which we refer to for a statement of the broad principles of public policy as a ground for setting aside or denying enforcement. But there's a throwaway line saying, of course, if there's serious error, and the error is not even so egregious as to be cursed by bell, book, and candle. So it's a standard a little bit higher than that that gets you past the post. So theoretically, there is this recognition of the possibility. The 2 jurisdictions which have actually put this into practice, one, India, and this is a well-publicized example in a case called, I always call it ONCO, I think Oil and Natural Gas Corporation of India against Saw Pipes, which is a rather well-known and even notorious decision where the Supreme Court of India actually declared that a patent error of law would be sufficient to set aside, and it did set aside an award on that ground. But I think I haven't followed this, currently, but I believe that in India, there has been a retreat from this principle through the case law, and Indian lawyers here can educate me on that. And finally, the one case which fair and square has taken on and applied the doctrine of egregious error is from Zimbabwe, where the High Court of Zimbabwe set aside commercial award. Actually, I think not even a commercial award, it was an employment dispute for what they called a serious error of law, which was actually an error in computation. Now, unfortunately, the report of this case is very small. It's the full report isn't easily available, and I have not been able to access it. But this is the only known example where a national court has out and out said egregious error is a ground for setting aside or denial, and we will do it. So that's case law. But in Singapore, Justice Prakash has been at the forefront of rejecting any attempt to introduce this. Saw Pipes has been rejected by the Singapore courts very shortly after it came out. And I think the relevant case of Justice Prakash is the Sui case, which she decided in around 2010, and then it went to the Court of Appeal, and the Court of Appeal affirmed the judgment. So Singapore is very firmly of the view that no errors, however egregious, of fact or law, and by whatever cloak it comes disguised in, it will not be a ground for challenge or setting aside.
Thank you, Michael. Thank you. Thank you. I think Justice Ma has something to contribute in this area also. Yeah.
I take the view that law is pretty clear on this, that in terms of errors of law, the court simply doesn't look at this. I agree with Judith Prakash in relation to this. If you want a recent statement of what the position is, of course, the Privy Council is in June restated the position in terms of looking at errors of law in this Mauritius Privy Council case, the Betamax and State Trading Corporation or that name, where the court doesn't look at the merits, doesn't look at the law at all. And that is a simple enough formula. The complication arises is when the point is actually raised. Now, Michael Hwang talks about it. It's just not going to be on if it comes under the disguise of something else. My query, and it is only a theoretical one, because you don't see any cases, I don't know of any cases anywhere, is where it is not disguised, when the error is actually so egregious that it actually points to an element of unfairness in the proceedings. And that has always been you're fairly and squarely within the public policy grounds or in resisting enforcement. Now, I say it is more theoretical and real because it just never happens, because most arbitral awards, commercial arbitration awards, might get the law wrong, but is never going to be that egregious. Actually, the word egregious is not a very precise term at all, because what is egregious to one person may not be egregious at all to another. This gets me back to my point that when it comes to the court of enforcement or any court looking at an issue of whether an error is sufficiently egregious as to merit court intervention, you need people, judges, who are experienced in arbitration, preferably as arbitrators, or at least experienced in dealing with arbitral matters. But the law is very clear on this, and the practice reflects that.
May I just add something? Some of one or two egregious errors of law can be, to an extent, reconstituted as failures of natural justice or failures of procedure. And there was a recent case where one of the grounds on which the award was set aside was that for some reason, the arbitral panel had awarded a rate of interest which both parties agreed was inapplicable. So I think that was set aside, that part of it was set aside on the basis of failure of due process, because they made an error and they completely disregarded what the parties had agreed. Yeah. But without such clear situations, as Justice Ma has said, the law is clear. Sorry. I mean, things will not be set aside for egregious error. It has to be somehow a failure of natural justice.
Right. In fact, even the error made in terms of the rate of interest and not following is a ground for setting aside under New York Convention, under Article 34, because it requires the tribunal actually to follow the terms of the contract, and therefore it's also a process issue. So what we're talking here, of course, is something that goes so wrong that is patently illegal or shocking to the conscience of the court that maybe warrants sometimes some intervention. And I believe in Canada and the US. If
it's shocking to the conscience of the court, then it'll be set aside on grounds of public policy.
Public policy.
So we don't have to worry about egregious error. Those are, errors of law, not illegality, and not things that shock your conscience.
Right. It might be a finding that's shocking, like in the US, they have the term, or in Canada as well, manifest error of law. But of course, that is manifest error of law, which is not something that which is permissible under model law. Sorry, Justice Ma, want to jump in?
No. Okay. Sorry. Gosh, you could read my thoughts. I had actually rather an impertinent thought, which is that Justice Prakash was talking about she doesn't look at the merits. I wish in my in my last case in Singapore, which is about 20 years ago, she didn't look at the merits. But unfortunately, she did, and I lost. So that's the only bit I wanted to say.
Thank you.
Geoffrey, I was tempted to say that when you mentioned the Betamax case that went to the Privy Council, that the Privy Council didn't look at the merits of the decision. That disappointed me a little because it was my award. I would have liked them to do
yes,
so.
Yes, I remember that. It was Michael Pryles' award. Yep, absolutely.
I think our time is just about up, Lawrence.
Secret is that. But I think Justice CJ Beverley wanted to jump in just now. Am I right?
No, I think everyone has made very learned statements. I think in Canada too, despite certain language that you find here and there, it's very, very difficult to get awards set aside on the merits. There has to be some clear departure that is so clear that it does almost amount to a fault of process, and things have gone off the rails. So I agree with everything that's been said, and I think it's probably good because courts are busy enough without having to go into the merits of arbitration awards, and I'd have all sorts of worries about, along the lines of Judith. Will courts of appeal really appreciate what was going on in the arbitration and all of those sorts of things? So I think it's probably good that it's confined to very, very serious and almost on the face of the decision type errors.
Thank you.
So
Thank you.
I think Lawrence, we're just about up. I might say a few words and invite you to say a few words.
Thank you.
If that's okay. So we've covered a very broad topic and made some very interesting points. I particularly fasten on the wise counsel which we've received from the panel, and Geoffrey Ma spoke about the obvious fact which we must never lose sight of, that we're all involved in the administration of justice. And we may go down slightly different roads, but that is our aim, to efficiently and honestly and to the best of our ability resolve a dispute. When we talked about cooperation and complementation between the two methods of dispute resolution, of course there is a lot. We also said a few words about competition. Sometimes I think the word competition is used in a pejorative sense to suggest something improper or unseemly. But I have no problems with competition. I don't see why different products cannot be offered to the commercial public to use as they think fit. I don't think there's anything unseemly or wrong with that. So any reference to competition, I don't think it's derogatory, or it should not be regarded as derogatory, but we're all going for the same end result, efficient and good dispute resolution. So just from my perspective, I'd like to thank our very distinguished panel for their excellent comments, which were very insightful. Over to you, Lawrence.
Thank you. Thank you, Michael. Thank you. First, I must apologize for all the judges and the panelists here for the way I've asked and posed questions. Maybe I have been a little bit too enthusiastic in the way I have done so. I hope you have not incurred the wrath of any of the judges here. Let me just also thank them also for their contribution and thoughts that they've shared so frankly, honestly, and brutally. And also, I must say that it has provoked quite a lot of questions. There were some that said that actually were quite strongly worded to say that, no, I can't see any reason why judges should be double hatting as arbitrators as well if they are sitting in courts. There are also expressions by other who say that why can't we also take into consideration manifest disregard of law as overall doctrine for when reviewing awards or enforcing awards? There are quite a few, and of course, some very sharp ones pointed out that Pryles was the chair of the Betamax case that was brought up by, they went before to the Privy Council. And in all, I think there are also expressions of thanking the tribunal, the panelists for your contribution. And I think there has been a very fruitful and lively discussion. Thank you so much. And for allowing me also to ask questions. It's very rare that I could ask questions of judges. Thank you very much.
Thank you.
Thank you.
I think that ends our session.
Yes.
Okay.
Thank you to the panel for that insightful discussion. And thank you to Justice Prakash, Justice McLachlin, and Justice Ma for joining us today for the SIAC Virtual Congress. That brings our plenary session to a close.